Hello, everyone, and welcome to the next edition of the Baker Botts Energy Enforcement Insider, our monthly 30-minute program that provides quick hits on the latest trends and developments in investigations and enforcement matters impacting energy market participants. My name is Michael Loesch in DC, and with me today, as always, is Brendan Quigley in New York. Thanks again for joining us. Today, we'll be covering a few interesting topics, SEC, ESG-related enforcement actions, recent comments by the SEC Enforcement Director, and some recent CFTC enforcement cases, one that just came out recently, Powerline, and another, Starbury. Again, appreciate you joining us, and let's get started. Here's our agenda. And we'll jump right in, and I'll turn it to Brendan to kick off regarding ESG-related enforcement out of the SEC.
Thanks, Michael. So, I'm sure most folks or everyone on the call is aware and has heard the term ESG before. Obviously, very hot topic in the energy industry and in the economy more broadly. Back last year, in March of 2021. The SEC announced that it was forming an ESG task force within the enforcement division to investigate and pursue ESG-related violations. And significantly, this is different than some of the proposed rulemaking that's been going on. This is the SEC's enforcement division, doing ESG-focused investigations using their existing authorities. And it's taken a while to take shape. There was a speech by the SEC Enforcement Director, Gurveer Grewal, in November 2021, where he kind of laid out a roadmap of what this task force would be looking at. And he said, for issuers, the touchstones are what always are the touchstones for the SEC: materiality and disclosure. And the key quote is there. It highlights, if an issuer chooses to speak on climate or ESG, whether in an SEC filing or elsewhere, it must ensure that its statements are not materially false or misleading because they omit material information. And then he also talked about how the SEC might apply how the ESG task force might look in the asset management space at investment advisors, investment companies, and others. And there, really, the focus is if an asset manager is marketing an ESG fund or strategy, it must do so in a way that's not materially false or misleading while adhering to client mandates and restrictions. And he also noted the written compliance, the need under Section 206 for written compliance policies and procedures reasonably designed to prevent violations of the securities laws. This was kind of a useful roadmap, this kind of roadmap focus on issuers and then asset managers, in that this is kind of how it has played out over the last several months. And we've seen the ESG task force bring its first two enforcement actions, one against an issuer, albeit a non-US based issuer, and the second against an investment advisor. So the first case was against an issuer. It's called a case called SEC v. Vale, filed in the Eastern District of New York on April 28th. This is a litigated action. It's still pending, still pretty early on in the case. And obviously, it goes without saying that these are just, at this point, allegations. There's been no settlement, no judicial findings, or jury findings or anything like that. Vale, as you may know, is a Brazilian iron ore producer. One of the interesting things here is this is not a U.S.-based issuer, so the SEC asserted jurisdiction essentially based on the fact that Vale has ADS, American Depository Shares, and several series of notes referenced with the SEC pursuant to Section 12B of the Exchange Act. It also has, and those ADS, those American Depository Shares, and those notes trade on the New York Stock Exchange, and perhaps more importantly, it also files periodic reports with the Commission, including under Forms 20F and 6K, including Forms 20F and 6K. And that is some of the misstatements that the SEC pointed to in its complaint. The real core allegations in the Vale action deal with false and misleading statements to investors. And essentially that in periodic filings with the SEC, including those types of filings we just referenced, presentations to investors, sustainability reports, and even ESG webinars, the company allegedly touted stability declarations regarding the stability of its dams, and reassured investors that the dams were safe and stable. As you see down there at the bottom of the slide, unfortunately, one of those dams, in fact, collapsed in 2019. And the SEC, the complaint cites an October 6, 2016 investor presentation where the company claimed its dams had been audited to address the potential for liquefaction, including a rigorous process that was conservative in its modeling, that there were international auditors involved, that it conducted a rigorous review of engineering studies that had incorporated new regulations requiring an analysis on undrained conditions, that had incorporated in its analysis lessons learned from a prior dam accident, and that it had taken actions for dam safety beyond all legislative requirements. And again, as alleged in the SEC's complaint, in fact, some of this information, there was material information was concealed from the dam safety auditors. In some of these safety practices, the company allegedly disregarded best practices and minimum safety standards, and in fact, allegedly changed auditors and firms who threatened to give it unfavorable results. So that's the Vale action. We'll talk about some lessons learned here in a couple of slides. But the other action in the investment advisor space, this was a settled action, and that should be 22, not 02, filed May 23rd, 2022, against BNY Mellon Investment Advisor, Inc. That allegedly, and it was really a sub-fund of this, a sub-advisor was really allegedly the culpable party here, that the investment advisor represented or implied in various statements that all investments in certain funds, and these are certain ESG-focused funds, had undergone an ESG quality review, when in fact that was not always the case. Numerous investments held by certain of these funds did not, in fact, have an ESG quality review score at the time of the investment. Vale was in action under 10b-5 and Section 17 of the Securities Act, dealing with material misstatements in connection with either the purchase or sale of a security, the offering and sale of security. The BNY action was brought under the Advisors Act, under Rule 206 4-7, which was the kind of the catch-all. You need to maintain compliance procedures to prevent violations, and then under Rule 206-2, which prohibits an investment advisor directly or indirectly from engaging in any transaction, practice, or course of business that operates as fraud or deceit upon a client or prospective client. And as I'm sure many of you know, that does not, at least the SEC's position is, that statute does not have a scienter requirement, a non-scienter resolution under Section 206.2. Another thing that worth noting about the order in this case is that the company paid a relatively nominal penalty. I think it was like $1.5 million, and the order noted the remedial steps that that BNY Investment Advisor had taken, and its cooperation in the investigation by providing detailed factual summaries, making a presentation on key topics, and the staff concluded that level of cooperation, quote, advance the quality and efficiency of the staff's investigation and conserve commission resources. There were also certain, in addition to the cooperation, there were also certain remedial measures that the staff pointed to in its order that it viewed favorably, including revising certain disclosure language and some process improvements that really didn't get too specific, but they at least highlighted that those had taken place. So those are the first two actions out of the ESG task force. What's next? And again, as I alluded to at the beginning, these enforcement actions take place kind of in parallel with the SEC's proposed climate disclosure rules, which were unveiled earlier this year. That generated a significant amount of comments. I think hundreds of comments and backlash. So it remains to be seen how those will play out. And in addition, the rulemaking process, this isn't really, necessarily, there's no active litigation going on about this yet that I'm aware of, but, a number of you may be aware that back at the end of June, at the end of the term, Supreme Court decided a case called West Virginia v. EPA, in which it held that the EPA had exceeded its authority in regulating certain emissions. And that's really beyond the scope of this webinar today. But the thing they relied on, and the thing that dissent in West Virginia v. EPA accused them of reviving or creating, I guess, was this thing called the major question doctrine, where the agency must point to, quote, clear congressional authorization for the authority it claims. And, a number of folks, commentators and the like, have raised West Virginia v. EPA and the major questions doctrine as potentially implicating some of the SEC's, or potential being a basis for challenging some of the SEC's climate disclosure rules if and when those are implemented. So, I think the takeaway is for that is in the mean, from the enforcement side of the House, the SEC is going to have to rely on its enforcement authorities, regulation by enforcement, until it gets this new rulemaking authority. What can we learn from the two cases that have been filed so far? Clearly, it's an area of focus for the Enforcement Division. They're using old tools. We talked about this, Rule 10b-5, Section 17a, Advisors Act, statutes and rules that have been around for, 90, 80 years now. But, I thought one thing that was interesting about the Vale complaint was that it contained a fairly detailed discussion, going on for dozens of pages about international guidelines and best practices around dam safety. In particular, some of the factors used to assess liquefaction risk. And while there are allegations that the company deliberately concealed safety data from dam auditors, they really went to great lengths in the complaint to focus on the operational side of the business, and less so on kind of the financial reporting side of the business. So I think it's critical, and if you're assessing ESG enforcement risk, to make sure that those folks who are dealing with operational safety and environmental issues, that those lines of communication to the financial reporting folks are in place, and that they're being used, and that people understand exactly what the operational risks are from an ESG perspective, but frankly from any perspective. Really highlights the importance of having clear lines of communication within the organization. I would also say, it's not a bullet point on here, but the Vale case once again highlights the broad reach of Rule 10b-5. It does not, liability under that rule does not need to be based on misstatements in an SEC filing or an official report. That certainly was, they had those in Vale, but they also talked about the sustainability reports and investor presentation. It's any misstatement or omission made in connection with the purchase or sale of a security, which is a pretty broad standard. And the third point here, again, just bad facts make bad cases. I mean, and not to, obviously this mine accident in 2019 is a horrible tragedy, but it's another example of, there's that Bloomberg commentator named Matt Levine who talks about, has this line, everything is securities fraud, meaning anytime a public company has an accident, there's generally some type of securities fraud allegation, either by the private plaintiffs bar or an SEC investigation, because the plaintiffs or the SEC point to, with the benefit of hindsight, to alleged misstatements in the company's filings concerning safety or other issues. I mean, we've seen this in a number of industries recently. And then, I guess, finally, and on the legal issues, again, it's an important reminder of the core securities principles, and this again dovetails with the idea that there's no, the SEC, there's no line items necessarily for ESG reporting in any SEC forms, but you don't need to. But if you do disclose something, you have a duty to be both complete and accurate. And cited 2010 case there, but that's pretty well established. Certainly in my experience in the Second Circuit and the Southern District of New York, pretty established principle, and I think pretty much across the circuits. Once you choose to speak, you have a duty to be accurate and complete. And then kind of relatedly, on the issue of materiality, the corporation is not required to disclose a fact merely because a reasonable investor would very much like to know that fact. But again, as the quote above that says, once you disclose it, it has to be accurate and, most importantly, in these circumstances, complete. So that's kind of the ESG task force landscape as of today. Michael, anything to add on that?
Yeah. I would just say, from a practical perspective, it highlights the need to really pay attention to disclosures in this area, and focus on how information is being prepared and put forward to investors and in public filings. This is a key topic and will be for the, I think you have to anticipate for the next few years at a minimum. So, it's really important to sort of, re-examine how your compliance processes are developing information for disclosure, and ensure that you've got, appropriate procedures in place to, ensure that information that goes out is, appropriate, accurate, and not misleading. So that's all. We should probably move on to the recent comments from the enforcement director of the SEC that are sort of continuing evidence that this commission is going to be very aggressive in terms of dealing with the companies and individuals that they're investigating, and including its dealings with counsel for those parties. So do you want to jump into that real quick?
Yeah, no, 100%, and we won't spend a ton of time on these two slides, but the SEC's director of enforcement, Gurbir Grewal, gave a speech in May. It's about 6 weeks ago, 2 months ago now, at the Securities Enforcement West conference, and really focused, as Michael said, on kind of the role of defense counsel, and frankly taking some umbrage at least his perception of the role that defense counsel play in some of these investigations. And look, this is not to to agree with any of this, but this is kind of the environment, again, as Michael alluded to, that's out there, and that we're seeing in some of the cases we deal with. We're hearing about others from our colleagues, both at Baker Botts and other firms dealing with, that there's definitely a more aggressive tone, and this is kind of like public evidence of it. He talks about, this is all quotes from his speech, but delays in productions. I think one thing here is investigative testimony is kind of many of you sure been involved in it, but SEC investigative testimony, at least in my experience, it's kind of a hybrid between, a formal civil deposition and an informal witness interview, where sometimes there is room for counsel, unlike in a civil deposition, to step in or clarify a question or to kind of work with the staff. I mean, again, it depends on the case and the member of the staff. But the rules of evidence don't apply. And, Mr. Grewal's concerned about that. People objecting and lodging hearsay objections and things like that. I mean, again, I think a lot of these issues, it depends a lot on who you're dealing with in the staff, but a lot of these issues I think can be mitigated or avoided by engagement with the staff before you have the witness testify, right? I mean, or at least attempting that type of engagement. Michael, you have any thoughts on that?
Yeah, no. Look, it always depends on who the individuals are in a testimony session, but the underlying tone to these remarks is, they'd like counsel to sit there quietly and, not say anything. And I'm not sure that's consistent with being a zealous advocate for your client, including in a testimony session. So, but it is important to understand that this is the environment and this is the messaging that the staff attorneys are receiving from their supervisors. So, so it's something you have to factor in, and it is important to try and maintain credibility with the staff, and if you can, but ultimately, you don't need to be friends with the staff. You just need to get a good result, and sometimes that means having a good relationship and good rapport, and other times it means not. You just have to be very cognizant of the messaging that the staff is getting and how that might impact your approach.
Yeah, and the only other point I'd make on this, and then we just move to the next slide here, is what Mr. Grewal highlighted is some examples of good cooperation. I know, sometimes clients will say, "Oh, we cooperated," like this. So, but what is the staff? What is the staff hearing from the enforcement director about what qualifies as good cooperation or cooperation? That would result in reduced penalties or no penalties at all. And I think here the things are, he points to, highlighting hot documents, providing translations of key documents where applicable, flagging documents, and making presentations to the staff that meaningfully illuminate events. Again, none of this is new, and I think most of us who've been involved in SEC investigations have, depending on the facts and circumstances, depending on the client's position, have at times, when appropriate, undertaken some of these actions. But those are the things that, number one, the staff is looking for. And I think number two, more importantly, as an advocate, if you have in fact done an investigation, these are the types of things you can point to when it comes time to negotiate a resolution and say, look, the director of enforcement highlighted this. These are things we actually did, and we should get, reduced penalties or no penalties at all.
Yeah. That said, you have to take every case on a facts and circumstances basis and ensure that, given the overall context of the matter and the underlying facts and the law and the posture of the matter, that, seeking this kind of extraordinary cooperation credit, for your benefit down the road is worth it ultimately. And right. Those can be difficult decisions and important conversations. So, they're going to be, investigations are going to, raise these issues more and more, and you're going to have to be, able to work through them, I think, more often during investigations as a result of the views of the staff right now.
All right.
So should we move on?
Let's move on to CFTC, Powerline, Michael.
Yeah. So the CFTC announced a settlement earlier this week in the matter of Powerline Petroleum. This is a pretty interesting case, one that I recommend you take a look at. The CFTC settled charges against Powerline and two individuals for misleading clients, making false statements to the exchange, to CME, and for failing to register as a CTA, a commodities trading advisor. The factual background is, Powerline's a registered introducing broker, working with clients with respect to hedging strategies involving options on energy futures. The commission found and alleged that Powerline committed fraud in connection with the activities with its customers by failing to disclose that it was acting as a counterparty to its clients in some of its transactions that it was introducing, and charging an undisclosed markup to those clients, and also making some false statements, specifically claiming that they were in fact disinterested when they were in fact a counterparty and charging a markup. CME conducted an initial investigation, and the CFTC alleges that Powerline provided a backdated letter to CME, and that constituted a false statement to CME. And there are further allegations that Powerline acted as a CTA without being registered, and therefore violated registration provisions as well as the disclosure requirements for those acting as a CTA. So that's those are the facts. So they're fraud charges against all three, the company and the individuals. False statements against all three. They brought also charges against the head of the company, Dome, for the CTA registration and disclosure violations, and they did that under a control person theory. And so, as you can see here, there's disgorgement, civil money penalty, not a huge penalty, $375K. But it's a pretty harsh case, a pretty harsh result, specifically because of the trading ban. They instituted a 6-month trading ban and a 3-month registration ban, not just for registration as a CTA, but impacting their existing IB registration as well. So one of the things that makes this case interesting is the dissenting statement from Commissioner Mercinger. Recommend you take a look at that. It's a pretty strong dissent. She supported the facts related to the false statements to CME, but felt the rest of it was overly harsh given the facts, particularly given the fact that in 2016 there was another similar action against Angus Energy that was settled under different terms. It didn't include a fraud charge. It didn't include individual liability. It didn't include registration and trading bans. So, her view of the facts was that this was inconsistent treatment of similar facts by the commission, and inappropriate and overly harsh. Also, she thought that the charges for failure to register as a CTA were potentially not supported, and weren't really addressed in the settlement order directly with any detail. But in her view, the facts indicated that as a registered IB, they didn't need to register as a CTA because the activity that they were conducting was solely in connection with their business as an IB. And her view was that the fraud charges were unnecessary, and in particular because this is a small company, her view was, these remedies, including the trading bans, have a substantial and significant impact on Powerline's business, and may put them out of business, in fact. They also noted that NFA did an examination and didn't find any problems or note any problems. So what are the key takeaways from this? I think this shows aggressive enforcement. We're seeing that at the SEC. We're seeing it at the CFTC as well. Individuals are going to continue to be at risk, within that aggressive enforcement structure. What's the real meaning of precedent, of similar factual scenarios that have been resolved previously? I think you have to assume that they play only a limited role in the commission's analysis, based on this case, and I think more broadly if you look across similar matters. Be cautious when responding to exchanges. Right, this is another case where there were charges of false statements to the exchange. False statements to exchanges are a priority, and so you really have to focus on what you're providing and making sure that what you're providing is responsive and accurate, and be measured in your responses to exchange inquiries. And this just highlights compliance. Compliance is key. In an environment of robust enforcement, a good compliance program is more important than ever. And no matter what size your business, even if you have a small business, you do need to put sufficient effort into compliance to ensure that you're not put out of business by a difficult enforcement settlement that includes trading bans or harsh remedies. So I recommend you take a look at that. It's an interesting case. One other case just to highlight before we close out is the Starbury matter, which was a case involving failure to register as an FCM, as a futures commission merchant in connection with WTI crude oil futures contracts. It was a $1.3 million penalty. In this case, the company accepted $400 million from foreign customers and executed trades on NYMEX, making a profit and receiving a commission for it. So in those actions, they acted as an FCM and were not registered. This is an interesting case. I think it shows some of the takeaways. Registration failures are a continuing focus. Global reach is something that the commission has, and this case demonstrates, even with a foreign company taking actions overseas for foreign customers, as long as they're on the U.S. exchanges, they can be pursued. One interesting thing here is the one-for-one penalty and disgorgement structure. So they had a $1.3 million penalty plus 1.3 in disgorgement. So that's something I think that you may see more of coming down the pike. The other compliance aspect that I would address with this is this activity for Starbury was a new business. It was something that they hadn't done before, and so they did it really just twice, and it resulted in this issue. So whenever you're changing business activities, doing something new, conducting a new trading strategy or some different set of customers, something new in your business, really have to consider the regulatory implications and ensure that you've addressed the compliance implications before engaging in that business. So that's probably the most significant takeaway from this one. So that's really all we have. I know we've run over time. We don't like to do that. Do you want to cover this last quick hit, Brandon?
Yeah, 30 seconds. Case to take a look at, SEC case, SEC v. Brinks, filed, I think, earlier this week or last week. Just another case where the SEC felt that a separation agreement that a company had put out chilled whistleblower activity. This issue comes up from time to time, just something to be aware of. happy if anyone has questions offline about it, happy to discuss. But that's just the only quick hit there. So,
Brandon, the other, I do have one other quick hit. The CFTC did extend the comment period for the climate financial risk request for information, another 60 days to October 7th. So there's still time to review that and coordinate potential comments to that request for information. So. With that, I think we'll close out. So thanks again, Brendan. Thanks everyone for joining. Appreciate your time, and feel free to reach out if there are any topics you'd like us to cover in the future, or any questions you have.
Thanks very much. Take care, everyone.
Bye-bye.